We're inside a courtroom where rules and timing matter just as much as feelings. This isn't the main trial yet. This is the pre-trial phase, where each side makes moves to shape what the jury will see later.
Court, all right. This honorable court's now session. Be seated, please.
Good afternoon, Your Honor. Good afternoon, all. This is called the criminal court list for Plymouth County at Plymouth on 2/20/2026. The first case that we're going to call is number 2 on our list, 2383 CR 19.
The big question right now is simple: who is shaping the story before the trial even starts? The case being called is Commonwealth versus Lindsay Clancy. It has already drawn national attention. But today's focus isn't about deciding guilt or innocence.
The case of Commonwealth versus Lindsay Clancy. This case is called for motions for the record. The defendant is present before the bar. Counsel for the record, begin with the Commonwealth.
Good afternoon, Your Honor. Jennifer Sprague with the Commonwealth.
Mr. Sprague, good afternoon.
And Shannon Buckingham, also for the Commonwealth.
Mr. Buckingham, good afternoon.
Good afternoon, Judge Kevin Reddington on behalf of Lindsay Clancy.
Mr. Reddington, good afternoon. Ms. Clancy, good afternoon. All right, so this is a matter gone for a number of reasons here today, I think. But first, I just kind of want to know, we've talked about the evaluation. I know there was a motion that was just recently filed. And by recently, I mean just the last day or so. So I'm not sure we're going to address those motions that were filed. We'll need new date on those. But one of them that was filed that I didn't know if we could take up, and that's one regarding the taping of the Commonwealth's evaluation. Now, I know we've talked about this for a number of times, so I didn't know if we can address that of the Commonwealth's position. My understanding was that there was no objection to the taping of the evaluation, with the only proviso on that dealing with some of the actual testing. So I don't know where we stand on that. Commonwealth?
Yes, Your Honor. I did just receive these motions yesterday, so I don't have any case law to argue or anything like that. But our position was that we had no objection to the recording of the examination of the defendant. We would only object to recording of the testing process because of proprietary rights for the standardized testing.
It's about mental health evaluations and how they will be handled. In criminal cases, psychological evidence can have a major impact on the outcome. Now things turn technical. Prosecutors are not against recording the interview itself, but they object to recording the standardized psychological tests. These tests are copyrighted tools, and there are restrictions on recording them. However, the defense has a different concern. They want transparency. If the testing isn't recorded, it becomes harder to question later whether it was done properly. At one point, the defense responds with sarcasm, making it clear they believe this isn't about protecting test companies.
Businesses and enterprises, number one. Number two, personally, I don't really care about the proprietary rights. My concern is what the actual tests are going to be, how they're going to be implemented, how they're going to be administered. And I can speak to certainly Dr. Zeisel as one of my consultants who's here today. I can speak with him regarding that. I know as far as the testing is concerned, usually it's, the usual judges. You're well familiar. sort of multi-phasic personality, the Beck inventory, all of those tests. So I don't really have a problem with them not videotaping the actual filling out of the squares and the actual test. So I think we can agree that it would be the interplay between the government's doctors and Lindsay, as far as them asking her questions and her related statements, that would be videotaped.
Well, I don't know if the parties can come to a stipulation. If we can't, my suggestion is to pick a date to argue this motion
Okay.
prior to, if I remember, sometime early April, the dates that have been set. And that would allow all parties to kind of get meaty information as to the need for not taping the testing or the no need for it. So then I can fashion a decision at it, but I want to make sure that it doesn't slow down or interfere with the actual testing.
Your Honor, we have the testing scheduled for April 10th.
Right.
I may have misheard, but I thought defense counsel just said that he had no objection to not recording the testing. So if that's the case, then I think
They argue it's about protecting the defendant's rights. In serious cases like this, even small comments can reveal how intense the legal strategy really is. What we're seeing is real-time negotiation. Pre-trial hearings are often less dramatic than people expect, but every decision matters.
we could come to an agreement.
Mr. Rankin?
Again, I just would like to consult with my own experts regarding that, but I feel myself that I don't really have an issue with not recording the filling out of the little squares and that type of thing. I have no problem.
All right, so what do we do this? I'm going to allow the videotaping of that. That will include the testing as well. If either party wants to strike that or impound that part of it, if we can do that. Call
Could we do the reverse and just order the testing of the interviewing, and if there is some reason that defense...
to take, no, what I'm saying, there's no question about, it doesn't sound like either side is objecting to the evaluation itself being
Right.
videotaped. The only issue, it seems to be, is whether or not the testing itself is videotaped. And now I'm hearing it probably isn't much of an objection. So what I'm going to, my suggestion was to allow the taping of the evaluation and the testing. And if somebody wants to, for me to reconsider it and come forward with any additional evidence as to why the testing itself shouldn't be.
Well, I think that, it puts the Commonwealth in a position where we received this motion yesterday. I haven't had a chance to research it or respond, and yet there will already be a
Whether the testing is recorded could affect expert testimony, cross-examination, and even appeals later.
decision allowing that taping.
But you
that
want
we're
to tape
object-
it.
We're objecting to
You're
the
the one who
taping of
wants
the,
to, but you're the one who wants to tape, you want,
I don't want to tape the testing portion.
all right, okay. All right, so why don't what I don't want to do is I don't want to delay the testing.
Right.
So, how much time would you need to prepare for this motion?
As you well knows, I'm on trial now in Dedham Superior. I'll have a jury out probably Monday or Tuesday. I would say a lot of the courts are putting that stuff at 2 o'clock in the afternoon now, so it's a little difficult. How about the 2nd of March? Would that work? It's a Monday.
Three spread.
I'm preparing for a trial that starts March 9th, but could we do it more towards, March 23rd? And that gives us
Yes,
a couple
that's fine.
weeks before the testing's supposed to start?
I don't have a problem, but just so everybody knows, that testing's going forward on that day, no matter what.
I apologize, I just looked, I'm paneling with Judge Hussein on a triple homicide in Fall River on that 23rd of March. Right, but with handling and forward with that data and that is not the year. I mean, I could do, I mean, I'd certainly accommodate, you know, really, if you throw out there March 10th, you could be here in the afternoon.
Be on track.
Could we do March 2nd? I know you.
That's
it's a
fine.
week before purpose, and I don't want to jam you up in regards to that, but it sounds like, quite frankly, the defendant may or may not really object to the testing. I think he just wants the opportunity to speak to his doctor. And so it may not even need a hearing in regards to that. But if it is, it's going to be a fairly short hearing. Most of this could be done through affidavits if parties have an objection to it.
I think what the court would probably want to know is what is it, when they say protection of their proprietary rights, what is it they're concerned about? Is it that they don't want to videotape the filling out of the forms, or is it the actual content of the test? And I just don't know.
And I don't want to put the Commonwealth in the middle of this either. I know that you're dealing with other parties who want their position made known to the court. So I think we can do that. Most of it can be done through affidavits. Then I can take a look at it, you know, and then if we need it, we can have a short hearing on the 2nd. Does that work?
That's fine.
Okay, all right. So the motion regarding videotaping will be on for March 2nd. Other than that, in regards to the evaluation, any issues regarding the discovery that's required under Rule 14.4, I guess now, that's required prior to the evaluation? The Commonwealth satisfied that they have what they need?
Defense counsel has stated that he's turned over everything his experts have reviewed and all of the raw data from their testing. So relying on that, I don't believe there's anything else at this time.
All right, and if anything comes up, just a little bit, I'm kind of going through my checklist to make sure that we have everything. So it sounds like discovery for the evaluation is complete.
Small rulings now can have big consequences during the trial. There is also clear pressure on both sides. The prosecution only received the motion recently, and the judge already seems open to allowing recording.
There were two other motions that were filed. One is regarding juror information, the other is the motion to bifurcate. Is that something we can argue on the 2nd?
Yes.
Well,
Yes.
all right, why don't we do that? Because I just got those two, I reviewed them, but that'll give me a chance to go through those motions as well. So if the parties talked about, again, under, I know the three of you know this very well, but in regards to the exchange of the document reports, is there an agreement in regards to when Commonwealth's report is issued? Is there an agreement between parties that there'll be an exchange of the defendant's report as well as the Commonwealth's report?
We haven't talked about it, but as soon as we have the reports, then to turn them over and request theirs in return.
That's my practice, Your Honor, is that once the government's doctors file their report, I provide ours to them and vice versa.
And then, but, so when you get there, if that's any different, then just, we can address that in court. But that's been my experience as well. When they're both ready, there'll be exchange between the parties. Now, in regards to scheduling, well, you know, we've got the July date, trial date, then,
In court, preparation and timing are critical. No lawyer wants to appear unready in front of the judge. Another key issue is discovery rules. Both sides must share expert information before the evaluation happens. This prevents surprise evidence late.
but working backwards a little bit is maybe a final trial conference date, rather than a week or two ahead. My thought was maybe sometime in early June, because I imagine there'll be significant motions to eliminate that we'll have to address. And that'll give us time in case anything has to be kind of followed up on prior to the trial. But I kind of just wanted to bounce that off of the three of you. What are your thoughts? Come on.
I think that makes sense, Your Honor. I would ask that we keep the final pretrial date set for July 13th in case any last-minute issues come up, but I think it makes sense to have an earlier one as well.
Mr. Reagan?
I agree.
Yeah, so we'll keep the July 13th. It's kind of a true final trial conference we have. But we can pick a date maybe sometime earlier in June, mainly to deal with motions and eliminate.
So council, looking at the week of first, or the week of the 8th, and then the 4th, 5th, 11th, 12th.
I'm sorry, I'm scheduled to start a trial in federal court with Judge Saris. It's going to go for 2 weeks on the 1st of June. So I'd say anything the week of the 15th. Yep, that's fine.
How's that?
That's fine.
All right, so that'll be the final trial conference. Parties can have their motions to eliminate filed a week before, and we can address any of those at the time.
Does that work with you, with your staff, Councilor?
If it doesn't, I'll call you and get an extension.
Well,
Yeah, that works.
All right. And then
and I'm sorry, Your Honor, you said a week before or 2 weeks before?
2 weeks, why don't we say 2 weeks?
2 weeks.
That's probably better for everybody's preparation, including the court. All right, the other thing is, on March 2nd, we're going to deal with those motions. The defendant's request that she be brought in or by Zoom just for those quick hearings?
I'd like to have you here.
All right.
And I have to, if I may, on that issue, I would actually, strangely enough, like to commend the Sheriff's Department and our staff in Tewksbury that melded together incredibly and done just a marvelous job of transportation and supplies and taking care of our ancillary issues. So I just wanted to put that on record. Appreciate the help that the court provided in that regard as well. I would like to have her here if I could.
All right. So we'll see that kind of gives it kind of a short runway, so we'll try and get that done.
Okay.
If not, we can't get that done.
Not critical. I mean,
Yeah, we may have to have her on by Zoom.
That's fine.
That's all.
Understood.
The other thing in regards to that, I know the court had issued an order regarding the procedures, which is sealed because it mainly dealt with security issues. I also just kind of wanted to let counsel know, if, and it's in the order, if either side or any of the parties feel that order has to be amended or changed, just bring it to the court's attention.
Of course.
Okay.
Thank you.
All right.
Your Honor, if I could just ask, the March 2nd date and the June 18th date, are those at 2 p.m.? Or?
If we can, yeah. Does that work for you?
It does. I just wasn't sure if we wanted more time for the motions than Monday.
Oh, June 18th?
Yes.
I think we should do the morning on that. Right, I was thinking that March 8th. Yeah, June 18th, because I don't know how long that those are going to be, so we'll do that.
Okay.
And let me see, 10 o'clock.
10 o'clock? Thank you.
With regards, other than that, anything else that we need to address first call?
No, Your Honor.
Defendant?
I don't think so.
All right, so we'll be in recess on this matter until we say March 2nd. And at that point, we'll deal with those motions that have been filed, any other issues that we have to. We've got the trial date, the 2 final trial conferences, and then if there's any issues regarding discovery, especially under Rule 14.4. Parties can bring it to my attention, we can deal with that.
Okay,
All right?
thank you.
All right, so with that, we'll be in recess on this case. Thank you.
Thank you.
Activity 3226, 2 p.m. Motion.
Court, all rise. Court's in recess. Please stay in the courtroom.